Get ready for the dictation. Start. First amendment to the Constitution of India was undoubtedly a momentous one. However, it leads to this interesting question. When much thought and perseverance had gone into the creation of the magnificent Constitution, and some of the best minds in the country had been deployed in its creation, how did it come to pass that amendments became imminent so early in its life? The need arose on account of some judgments of high courts and the Supreme Court that interpreted the Constitution vastly differently from the manner the ruling class came to interpret it or wanted it to be interpreted. Journalist Ramesh Thapar challenged the ban on the publication of his English weekly crosswords. Similarly, a publication was banned in Delhi for allegedly hurting religious sentiments, which ban came to be challenged in courts. Brij Bhushan and another versus the state of Delhi. These restrictions on freedom of speech and expression came to be challenged before the Supreme Court. The Supreme Court, in the much cited judgment Ramesh Thapar versus State of Madras, held in no uncertain terms that securing public order was not one of the enumerated exceptions to free speech under Article 19(2). The other area in which courts differed with the executive was in the realm of land reform. To end the zamindari operation, some states gave low compensation to the zamindars and appropriated their land. Such measure was held unconstitutional by some high courts, notably the Patna High Court in Kameshwar Singh versus State of Bihar on 12 March 1951. The High Court held that the Bihar Land Reforms Act was invalid as it violated Article 14 of the Constitution. The court held that Article 14 guaranteed equal protection under the law and therefore it did not allow discrimination against the richer zamindars. In effect, they held that the compensation to be paid must be the same whether the land was acquired from a poor person or a zamindar. In all the cases, the provisions impugned and the acts in which they were placed were different. For example, in Ramesh Thapar versus State of Madras, it was the provisions of the Madras Maintenance of Public Order 1949 that was challenged. In Brij Bhushan versus State of Delhi, the provisions challenged related to the East Punjab Public Safety Act 1949. However, in all these cases, the Supreme Court addressed the single most important point, which was were these provisions constitutionally valid. A majority of the Supreme Court struck down the impugned provisions. In doing so, they invoked the doctrine of overbreadth. The court ruled that public order was synonymous and public tranquility and peace while undermining the security of or tending to overthrow the state referred to acts which could shake the very foundation of the state. It was therefore held that while acts that undermined or tended to overthrow the state would also lead to public disorder, it could not be said that acts against public order would be said to undermine the security of the state. This meant that the impugned legislations proscribed acts that under Article 19(2) the government was entitled to prohibit as well as those that it could not. In such cases, the court held that it made the laws overboard and consequently unconstitutional. In Ramesh Thapar and Brij Bhushan, the Supreme Court also held that the impugned provisions of the legislations imposed a regime of prior restraint. It held that the impugned provisions permitted the government to prohibit the circulation of newspapers in anticipation of public disorder. It held that they choked off speech before it even had the opportunity to be made, applying an accepted tradition in common law as well as American constitutional jurisprudence. The court held that a legislation imposing prior restraint bore a heavy burden to demonstrate its constitutionality. Stop.